Welcome to our first presentation on Chapter 7. This chapter has to do with HR matters. We have two chapters in this course that relate to HR or employment law issues. And the first has to do with how we go about selecting employees. The second chapter, Chapter 8, will talk about how we manage the employment relationship. So let's get started talking about the selection process. We're going to talk today about how we should go about selecting employees, how discrimination can arise, or at least the possibility of discrimination can arise while the selection process is ongoing. So we want to be sensitive and aware of the possible pitfalls with making unwise choices in the selection process. Then we're going to talk about how we confirm that somebody is eligible to work, that they meet the requirements both in terms of their age as well as in terms of their eligibility to work in the United States. And finally, we'll talk about what kind of relationship we're actually establishing when we do hire someone. What is the nature, what is the legal aspects of that relationship? So let's get started. Today we're going to talk a lot about job descriptions, we're going to talk about job qualifications, and we're going to talk about the interview process. Again, we're going to talk about how to avoid those charges of discrimination. No strategy that we can come up with will completely eliminate that possibility, but there are ways of reducing the chances of getting a charge of discrimination, and also, probably more importantly, reducing the chances that that charge of discrimination has merit. We'll talk about the I-9 process and how we use it to make sure that we're following the laws and we're only employing people who are eligible to work, as well as making sure that we're dotting all the I's and crossing all the T's. And then talk about how at-will employment works, because that's the nature of the relationship that in Texas employees and employers have with each other. And we'll talk extremely briefly on the topic of collective bargaining. It's not a big issue in Texas, and so I don't want to use a lot of class time talking about that topic. So let's get started. Obviously, one of the most important terms that we're going to work with when we talk about employment relationships is the idea of what is an employer. Here we go. Let me There are a couple of words that we use instead of employer sometimes. One word that we use is kind of an old-fashioned word, but is the word master. That is the legal term that is most commonly used, at least historically. And the word for the employee is servant. Now, I'm not at all suggesting you adopt these terms, because these are fairly loaded terms in our culture. And so they aren't ones that are a smart idea to advance with workers. But it's important to know kind of the historical aspects of the term. And when you're going through statutes or cases, you may sometimes see the word master and servant, and you may be confused as to what they're talking about. In the law, master means employer and servant means employee. So what is an employer? Well, it's an individual, in other words, a human being, a man or a woman, or it can be an entity like a corporation or a partnership or a sole proprietorship. You may recall in a previous chapter we talked a lot about various entity structures. All of those can involve being an employer. So we have an individual, human being, or an entity that pays wages in exchange for a worker's services. So that's the nature of it. Now there's actually, the textbook doesn't really go into a lot of discussion about this, but I want to touch on it briefly, is that sometimes managers in a business have a kind of a false sense of security about their status. They think to themselves, well, if I make a mistake in the employment relationship, the person with whom I make a mistake, he or she is going to sue our employer, and not necessarily me. And so while I don't want to make a mistake, it's not my neck out there, it's really the employer's neck. That isn't the case for most of the statutes. In most of the statutes, the person whom you have violated the law with respect to will certainly sue the employer. After all, the employer is the entity with the deep pocket. And when I say deep pocket, I mean the entity that has significant resources. Most employers have, millions, sometimes billions of dollars of resources. And oftentimes, or sometimes, I shouldn't say often, but sometimes we'll have insurance that relates to whatever the claim is. But in many cases, perhaps even most cases, the employee will also sue the manager who made the decision. And usually the employee, if the employee is successful with his or her lawsuit, will also be able to collect damages against the manager. So in this situation, the employer might well be the manager, not just the company that employs both the manager and the employee. So don't assume that simply because this is not your personal employee that somehow or another, if you make a mistake, that it's not going to be your assets that are potentially at risk. Let's go to the next slide. And that is no big surprise here. It's the word employee. So just like we had master for employer, we have servant here for employee. So what is an employee? Well, it's exactly what you think it is. It's an individual. Obviously, an employee can't be a legal entity. It's got to be a human being, a man or a woman. So an individual who is hired to provide services to an employer in exchanges for wages or salary. You may notice in both the definition for employee and employer, it sounds like really a contract is being formed. For example, we have consideration, the employee provides services, that's the consideration the employee provides, and the employer provides is wages or a salary, that's the consideration the employer provides. And so you're on the right track. We'll talk more about this later, but you can see how the employee-employer relationship is contractual in its nature. Let's go to our next slide. So we're going to talk about strategies that employers, and especially managers in this case, should consider when they are in a position to need to hire employees. And many times hospitality, or generally most hospitality industries, are very labor-intensive, service-oriented, and as a result, there needs to be lots and lots of workers. And there's typically a lot of turnover, that people may not have a long service situation, and so therefore it's a pretty big part of many hospitality managers to be interviewing and selecting employees. Managers, I suppose, in virtually every business do some of this, but I would say hospitality managers probably spend a greater portion of their time involved in the recruiting and hiring process. So we're going to talk about some key tools that you'll want to have available to you as you go through that process. One thing you want to have is a job description. Now, in many cases, the job description that you're going to be working with will be something that has been given to you by some corporate department. If you say we're to work for Hilton or Marriott or Darden's or Brinkers or something like that, I'm sure that there would be job descriptions that you would get from the corporate office, and you would be able to roll with those. On the other hand, if you are the manager of a mom and pop restaurant, very likely if there's going to be any job descriptions, you're the one that's going to have to develop it. We're not going to get into the nitty-gritty details about how to develop a job description, but we're just going to kind of talk about what it is and what its purposes are, and so hopefully that'll get you started in the right direction. We're also going to talk about job qualifications and what's involved with that. And the distinction, frankly, between a job description and the job qualifications. They're both important, but they're different things. And within the broader category of job qualifications, we'll also talk about BFOQs. More about that as we go forward. After we've talked about the job descriptions and job qualifications, and we'll talk about how we actually go through that process, because obviously these first two things that we're doing, these aren't things that really are dependent upon a particular candidate. We prepare these first two items before we've even put out our job posting, or hung a sign on the door, or told anybody we need to have any applicants. It's before we've even considered choosing or screening whom we want to interview and whom we do not want to interview. So these are kind of preliminary steps deciding what the job description, job qualifications are. Once we have these two done, then we're prepared to start this process of selecting between the candidates that we have. And of course, this is a very, very important part of the process. All parts of this, though, are fraught with opportunities to do great things for your organization, and also they're fraught with great risks associated with it. In many respects, the hiring decision from an HR perspective is one of the most risky decisions that a manager is likely to make, at least from an HR perspective. So you want to be careful in this area. In addition to it being risky, many of the risks may not be obvious to you in the moment. And so that can present additional challenges, because you may be making mistakes that you don't even fully understand or grasp would be mistakes. And so it requires a pretty sophisticated person to navigate this area effectively. Let's go forward from here. We have our next term is again that job description term. It is a written, itemized listing of a specific job's basic responsibilities and reporting relationships. This is an important document. You're going to want to have this for virtually every position. In fact, I would say probably you would have it for every position that is not really, really short term within your organization. The job description is the reason why you want to hire somebody. And so you'll describe the things that you want this person to accomplish when he or she is doing the job. This is an opportunity not just to describe the nature of the job responsibilities. For example, let's say we're talking about a waiter or waitress. You would talk about taking food orders, placing the orders of the kitchen, delivering the food, collecting payment, maybe doing some security type things to make sure people aren't walking out on their bill, that type of thing. And so certainly there would be some pretty obvious things that you want in your job description, but there might also be other things that kind of point to cultural aspects. For example, maybe in your particular organization, maybe the business model or the style of restaurant is intended to be kind of a down-home place. And so you might want greeters who are very friendly, very outgoing, very down-to-earth type people. On the other hand, if your restaurant is a very upper scale French place, you might want waiters who are more reserved, more formal in terms of how they interact. And so matching the characters, in all those restaurants you would have probably a pretty similar job description in terms of the actual tasks performed, but a person who might be very successful in one of those positions probably wouldn't be the best fit for the other. So it's important to use this opportunity to identify the expectations. This is, of course, useful in deciding who you ultimately want to hire, because you can go down the list and say, well, would Bob or Sally or Teresa or Jeff be better for goal number 1? Would Bob or Sally or Teresa or Jeff be better for goal number 2? It allows you to directly compare the individuals. It also helps you decide, what kind of questions you want to ask. If Bob isn't responsible for taking drink orders, let's say somebody else in the restaurant has that responsibility, then you probably don't need to ask Bob a lot of questions about wines and hard liquor and things along those lines. So you want to think through what specifically this person is going to need to do. The job description, though, doesn't cease to be important just when you're hiring somebody. It should be a part of the culture of the organization. And so as you train people, you'll want to refer to your job description and say, what do you want to train people? Again, in the down-home, kind of country restaurant, you might really emphasize the smile, the greeting, things along those lines. And so that would obviously, you'd want that to be a big part of your training. If it's the fancy French restaurant, you might really want to emphasize a correct pronunciation of the French words on the menu. And so that would be another emphasis. But you might actually not even want the waiters or waitresses to actively have a big grin on their face. And so you'd want to talk about those things as well. So that's the job description. And we'll talk more about how it relates to some legal issues in a later section of this presentation. Another thing that you want to think about are job qualifications, and usually this is kept in a separate document from the job description. This actually talks about what specific skills the person needs to have in order to be able to accomplish the job description. So let's say that the job description says that the waiter needs to be able to read and describe the items on the menu. Okay, pretty obvious. Probably the menu items might be changing on a regular basis. Well, a job qualification in that French restaurant might be to be able to read French and pronounce French in a way that is fairly authentic. And so that would be a qualification of that task. A qualification is distinct from a description. This is focusing upon what needs to happen. That's what a description does. And the qualification focus on what skills about the person doing it has to exist in order for that person to be successful. So things that it's going to contain are physical, mental, and educational requirements. You don't want to include extra requirements. There's a temptation here that sometimes arises either because you have kind of this wish list of things that you want, but there maybe aren't requirements. Imagine for a second, and there's been case on this, that you are, we'll just use Southwestern Airlines because that's what the case related to. Southwestern back in the 1970s had a bit of a different image. It really pushed the idea of love, L-U-V. That was kind of its thing. And while it was also a low-cost airline, it emphasized more, it was kind of focused upon attracting the male business customer. And so it really emphasized the fact that its stewardesses, and they were all women then, were fun and flirtatious and pretty. And so the idea was almost a little bit of a Hooters, not to that extent, but a little bit of that flavor in the selection process for the stewardesses in the Southwestern Airlines. And so one of the job qualifications, I don't know if they listed it technically or it was just by a practical matter that it became, was that the person had to be a woman. There were lots of men, obviously, that Southwest employed, pilots, mechanics, other people, but actually on the planes, all of the stewards were women. But then the question is, well, what is a steward supposed to do? Well, all of the tasks that steward was supposed to accomplish could be accomplished by a man. And so you can see how if you pick a job qualification that doesn't fully meet or is more demanding than the job description requires, you can run into trouble. The court in that case actually rejected the idea that you had to be female in order to be a stewardess. There's been a similar line of, at least investigations, relating to Hooters. Hooters has many men working for it. As I'm sure you know, Hooters is a restaurant and a bar that serves wings, and also kind of is a sports bar environment, and many or all of its servers are women, and they wear, how to put it delicately, flirtatious clothing. And they are usually attractive women who have nice figures. Now, there are plenty of men who work at a Hooters in the kitchen and I think perhaps in the bar area, but the actual wait staff are all women. Well, the EOC said, wait a second, men can wait tables just as well as women. The actual description, the tasks that need to be performed in a Hooters restaurant in terms of, getting the orders, delivering the food, taking the money, all that can be done by men. Well, Hooters' response is, Our customers don't want to get their wings from a guy. That's going to significantly diminish their enjoyment. They aren't going to come if they don't know or if they think they may not get an attractive woman dressed in a flirtatious outfit. As I said, part of the job description is that kind of level of flirtation, and so therefore, in order to meet that qualification, not only does the person need to be a woman, but that person also needs to be an attractive woman with a nice figure. And so there's that particular issue ended up being settled. We don't know exactly what the EOC and Hooters decided, but if you've been to Hooters recently, you've probably noticed there are still no men waiters. So, kind of connect the dots there. Also in the airline attendant area, there have been times where airline attendants have had pretty significant limitations on their size. They've been limited in terms of their body weight, and they've been limited in terms of their height. The argument that the airlines have sometimes advanced for that is that this is a safety issue, that there's relatively limited space in an airplane because, of course, it's expensive to build an airplane bigger than you need, so every square inch of the airplane needs to be used as efficiently as possible. And in an emergency, you want to have as people who can move into the smallest areas and rescue children and do other tasks. And if you had a bigger person, that bigger person might find it more difficult to navigate between the various items. So the idea advanced was a safety issue. But many times courts have found that maybe that wasn't the complete reason, that maybe a secondary reason, or perhaps even a primary reason for those rules, was that the airline wanted more petite women because they felt that some of the clients, the customers, were found those women more appealing anyway. And the courts, for the most part, have said, no, stewardesses are not there to be attractive. They're there to perform safety and other functions that are not connected to their physical appearance. Let me give you another example of a job qualification story. It's a little bit different. This one doesn't have to do with appearance. There was a case, this is several years old, but it's a case arising out of Alabama. This young woman was, she had graduated from college, and she applied. She had pursued a major in criminal justice, and she wanted to work as a guard in an Alabama prison. The particular prison to which she had applied was a prison that incarcerated male inmates. So she applied for the job, and the Alabama Prison Board had at that time a policy that said that in order to be considered for this particular job, this particular guard job, all successful candidates had to weigh at least 120 pounds. At this time, this young woman did not weigh 120 pounds, and so therefore her candidacy was not considered. And of course, this policy in and of itself was gender neutral. It didn't say that women couldn't be employed, and in fact, many women were employed in the prison system, including the ones that included male inmates, because obviously many women weigh over 120 pounds. And in fact, there probably are a few adult men who don't weigh 120 pounds. And so, I mean, it wasn't a 100% screener or with respect to weight, but it was a pretty significant impact. I mean, there's a fairly significant number of women who weigh under 120 pounds, but there's relatively few men who are at least 18 who don't weigh at least 120 pounds. And so it had what was called a disparate impact. Let me just write those words up here so you can see what I'm saying. A disparate impact on women. It also perhaps would have a disparate impact on certain minority groups. For example, many times Asian and Latina and Latino men, disparate impact, are smaller in terms of body size, and so they might be more likely to weigh a smaller amount than, say, Caucasian or African American men and women. So no one in the case claimed that the Alabama prison service wanted to discriminate against women or Latinos or Asians. There was no evidence to support that. And in fact, the argument that the Alabama prison service presented for why they required 120 pounds was kind of a sensible one, to some extent at least. And the argument was, look, prisons can be dangerous places. In a second, you can go from a situation, if you're the guard, that you're in control of the situation, to a situation where you are absolutely not in control. And so we need to have guards, whether they be men or women, who are able to protect themselves and also protect inmates. And the larger that a person is, the more likely they are to be able to protect themselves, protect the rest of the prison population. But our woman here who had applied for the job says, wait a second, okay, so what's the evidence for that? You know, why did you pick 120 pounds? Why didn't you make it 130 pounds? Or why didn't you make it 150 pounds? Or instead of making it weight-based, why didn't you make it height-based? Or why didn't you have the men and women who are applying for the job maybe require them to lift a certain weight or run a certain distance in a certain time frame? How did you pick this particular metric? Because maybe I'd be able to be successful with these other metrics, even though I wasn't successful with this one. And it doesn't really seem like, I mean, if I'd weighed, you know, maybe, I don't know how much this woman weighed, but let's say she weighed 115 pounds. If I'd weighed 6 more pounds, I would suddenly be able to protect people where I can't at 115 pounds. And of course, there could be somebody who weighs 130 pounds, but isn't any stronger, maybe has actually less muscle mass than somebody who weighs 115 pounds. So her point was it doesn't really seem necessarily tightly logically related. And the court ultimately agreed with the woman and said, look, you know, Alabama's argument might have merit, but the problem is that Alabama didn't do the statistical studies to prove that this is what was necessary in order to make the best choice. And so whenever you set up standards that tend to disadvantage one group, be they women or men or a particular ethnicity, you have, if that group is going to be less likely to be selected because you have this particular criteria, you need to be able to prove that that criteria makes sense, that that criteria is really necessary for the job. It's not just kind of, boy, it'd sure be nice. No, it needs to be necessary for the job. Let me give you some examples of some criteria that would work. If you wanted to hire, let's say you ran a dental office, if you wanted to hire a dental hygienist, in order to function as a dental hygienist, you have to have a license from the state. It could be that women, I'm guessing this is true, but that women are disproportionately represented in the group of individuals who have dental hygienist licenses. So you could say requiring that particular license would have a disparate impact upon men because the vast majority of people who have this license are going to be women. That would be true. But it would be okay because it would be unlawful for that dental office to hire anyone, man or woman, to be a dental hygienist if that person doesn't have the requisite license. So that would be an example of a licensing requirement that the courts would definitely enforce. Let me give you another example. Things that relate to safety. Imagine, and this is very common, that a fire department requires that its firefighters be of a certain height and be able to carry items a certain distance under certain circumstances. The courts have generally held that those are reasonable standards, even though they tend to exclude, again, women and certain minority groups who may not be as tall. And the idea is, well, yeah, it might be that fewer women are selected, but if you're in a burning building, you don't want the person to rescue you who's politically correct to rescue you. You want the person who can get to you wherever you are, and fire departments say that involves height. You need to have the height sometimes to get to the right person, get to the person who is in jeopardy. And so for that reason, generally when there's a safety component, the courts are going to defer to the expertise of that agency and say, if you really think you need this, we're going to trust you that this is a genuine requirement, if it makes sense, of course. So anyway, we've talked a little bit about job descriptions, and we've also talked about job qualifications. Let's move on to talking about the selection. Oh, actually, let's talk about bona fide occupational qualifications. This is not a big issue. It's actually a fairly rare thing that comes up, and it will be unlikely to come up in a hospitality industry to any great extent. But let's just go over it so we can kind of check this off. What is a BFOQ? Well, it's a job qualification that's established in good faith and fairness that is necessary in order to safely or adequately perform the job. So this is something that you have to have in order to be able to safely and effectively perform the job. Licensing is a good point. You might need to have your bartenders, for example, have a certain license. You might need, if you hire an HVAC person, that they might need a particular license for that particular function. But on the other hand, you couldn't, it would not be a genuine BFOQ to say, let's say that the housekeeper staff, a man applies and he wants to be a housekeeper to clean the rooms in the hotel. You might say, well, we think our customers, our guests would be more comfortable with a man, especially our female guests who are traveling alone. That they would be more comfortable with a woman, especially our female guests who are traveling alone. But in fact, the courts would say no. I mean, they're for one thing, a housekeeper is not ordinarily in the room when the guest is in the room, and there wouldn't be a reason that a man couldn't clean the room just as well as a female housekeeper. So a BFOQ that restricted that profession to women would be probably held to be invalid. Let me give you some examples of BFOQs that at first glance might seem discriminatory, but the courts have upheld. For example, while a housekeeper in a hotel room does not have to be a woman, you could imagine a fitting room attendant. There could be a requirement that that person be of the same sex that the fitting room is designed to serve. The idea here being that people are going to be in states of undress, and they're for personal modesty reasons, aren't going to be comfortable with having an attendant who is of another gender. Imagine that there was a man who became qualified to perform mammographies. A mammography is a test of the breast to see if this particular woman might have breast cancer. In order to perform this particular test, the woman does not wear anything above her waist, and the mammographer actually takes the breast and positions it a certain way on a x-ray type situation, and it quite significantly manipulates the breast to fit in that particular area. Most women, or at least many women, would be uncomfortable having a man to whom they don't know perform those particular actions. I think most women aren't that thrilled with having a woman do it either, but it's more comfortable than having a man. So in that situation, again, because it has to do with personal modesty, the BFOQ of requiring that it be a woman is probably okay. So when you're talking about personal modesty ideas, BFOQs are okay. Race and national origin can never be a BFOQ. And you can't consider customer preferences except really in that narrow area of personal modesty. So let's move on to the application process. Here's some BFOQs that sometimes arise. The ability to lift a certain amount of weight. Imagine that you have a requirement. Well, imagine that your the people who take the luggage, I can't remember, bellhops who take the luggage up to the rooms, and once they take the luggage up, then they're put it on a particular table or something in the room. Well, they have to be able to lift that luggage, and you might think, well, maybe that luggage can weigh up to 70 pounds or something along those lines. Well, then you'd want those bellhops to be able to lift 70 pounds. They wouldn't need to lift 300 pounds though, so you want to make sure that the expectation you have is reasonable under the circumstances. Education's a pretty dicey one. Many times employers will choose to have a BFOQ that really is not reasonable in this area, or that they will think they have one. It's pretty rare that any job needs a college degree, because there will be people who've done a good job in that particular job and they haven't had the college degree. That's true for most management positions. While most employers would prefer to have their managers have 4-year degrees or at least 2-year degrees, the argument that they have to is probably not a very strong one. So requiring a 4-year degree is probably not a smart idea to have on the list of job qualifications. But that certainly could be a factor that would make a particular candidate more qualified. While when I worked at JCPenney, the vast majority of managers at JCPenney, the vast majority of store managers for certain, had 4-year degrees. But I knew of store managers who only had high school degrees. Not a lot of them, but many times they were quite successful. And so to say that that is a qualification, it was necessary, would not have been accurate. So you have to be careful about these words. Is it something really is it something you would strongly prefer? Is it something that is highly predictive of success? Well, that's different than saying that you have to have it. Another area that you might see some BFOQs would be in language skills. Imagine this is the front desk of a hotel, and in your particular community, some of the guests may speak a different language, or at least prefer to communicate in a different language. And so under those circumstances, it could be a BFOQ that your greeters in that circumstance are fluent in that second language, and so that would be reasonable. On the other hand, if you don't routinely have guests who speak that language, and then you're still requiring it for your BFOQ, that would be a problem to have that. Minimum age requirements, or maximum age requirements for that matter. Sometimes they're required, for example, for waitresses or waiters to serve alcohol, or perhaps there's safety rules. We'll talk about those later, about what tasks someone can perform at certain ages. But as a general rule, once a person hits 21, there's not going to be any age requirements that they have to satisfy beyond that age, unless, of course, they're running for, I don't know, the U.S. presidency or something. Similarly, there's not going to be any maximum ages in the hospitality industry. There's a few niches out there that have rules that have upper limits, but those are very, very rare. So let's talk about one of the risks associated with making a bad decision. There's lots of risks. In fact, most of the risks are when you don't select someone. So saying no is a more dangerous choice in the hiring arena. It's a more dangerous choice in terms of legal liability than saying yes. Now, obviously, in the employment area, the hiring area, you're going to say no a lot more than you're going to say yes. And so it's going to be a standard part of your job. But I'm certainly not suggesting you hire people that aren't good for the job. But even yeses can be fraught with some risks. If you hire someone and once they're hired, they make some poor choices, maybe they injure others, or maybe these might be guests, or they might be coworkers. Under those circumstances, the person whom they've injured can potentially sue the employer, and yes, you individually, because you made a bad choice. Because after all, if you hadn't hired this person, well, they wouldn't have been there to harm whomever they harmed. Sometimes these are negligent hiring situations. Another thing we see in this area is what's called negligent retention. Let me see if I can get here we go. The other term is negligent retention. This is the idea that once an employer knows that an employee is bad news, he's making some bad choices, and that employer doesn't terminate that employee, or doesn't at least significantly monitor him, retrain him or her, then if that behavior continues or escalates, the court, or more likely the jury, might conclude that there's a negligent retention situation. Now, negligent hiring, there usually needs to be some evidence that this person had engaged in some bad behavior in his past, and either the potential employer knew about the behavior and chose to hire this person anyway, or maybe didn't know about the behavior but should have known about the behavior, should have asked better questions. So negligent hiring or negligent retention are tort theories that can come up. We'll talk more about torts in a later chapter, but that's a legal theory that the victim can sometimes collect under. So yes can be dangerous as well as no in the employment context. Let's talk about defamation. What is defamation? Well, defamation, first of all, has to be a false statement. So it has to be something that is untrue. You can't defame somebody by saying the truth about them. You also can't defame somebody by giving an opinion. For example, if I were to say, Angelina Jolie is very ugly. Well, even if I were to say this in a very public environment, Angelina Jolie could not sue me for that because that's an opinion. If I were to say Angelina Jolie had an affair with Donald Trump, that would be a statement that is either factually true or factually false. As far as I know, it's false. And so under those circumstances, Angelina Jolie and or Donald Trump could sue me for that because it is a fact that can be proven one way or the other. It's not opinion, it's a provable thing. It's either true or it's not true. So the first thing we have is it false or is it true? The second, is it a statement or is it an opinion? And then the next thing that we need to have for defamation is it a negative thing? Let's say I were to say, Angelina Jolie has won 10 Oscars. Well, I don't think that's true. It's certainly a statement that can be proven one way or the other. And it also, I think, is a false statement. But it's hard to see how that will harm her reputation or harm the reputation of the Oscar people. So we don't have any lowering of the esteem in that situation. So we really need all three of these things in order to have a defamation claim. So you may say, why are we talking about this at this particular moment in the class? Well, one of the things that you're likely to do when you're interviewing folks is you're likely to, and I certainly strongly recommend you try to do this, is to check references. And so when you're in the process of checking references, you're going to call former employers, maybe personal references, to find out a little bit about this candidate. And one of the things that you may hear at some points is you may hear some negative things about one of the candidates that you were considering. You may hear that they had a tardiness problem, or they were fired for theft, or some other negative fact about them. And then you decide to act on that fact. You decide not to hire that person. Well, for the most part, you're going to be okay if you act upon that information, assuming that the information itself is not racially offensive or sexist or something along those lines. But the person who gave you that reference may be on thin ice. It's not that a former employer can't give a negative reference, but the problem can be, what if the reference is defamatory? In other words, it's a false statement that puts that person in a bad light. Well, given the fact that it's a bad reference, obviously it's put that person in a bad light, and since it's probably going to result in that person not being hired, it's definitely cost that person financially. So the question is, well, is it an opinion or is it a fact? So was the person saying, oh, Bob's just not, I didn't really like Bob. Well, that's an opinion. You're not going to be able to have a defamation claim based solely on that. But if it was, Bob was tardy more often than any other person in the department, that's a provable fact. And if that fact is also false, then that person who gave the reference is potentially liable for defamation. One of the things that happens in the real world is that when that former manager gets called, he or she wasn't necessarily primed to answer those questions. He or she's answering on the fly, and especially in the hospitality industry, he or she may have seen a lot of employees over that period of time. There may be a lot of turnover, so it's easy to get people confused with each other, conflated characteristics from one in the mind of the person giving the reference might be confused with characteristics of another employee. And so it may not be intentional on the part of the employer to give a bad reference that is not accurate, but that can sometimes happen. And so that's what the concern there is, that we're going to give bad references inadvertently. So most employers choose not to give references at all, because giving a bad reference is just a risky thing. And really, what's the upside for the person giving the reference? I mean, does that help the former employer? No. I mean, it helps this new company that wants to hire, but it doesn't help the former company. And so as a result, many employers don't give any references, or they give just a very neutral reference, maybe dates of employment, last title held, salary or hourly rate at the time of termination. Those things are just facts that really aren't controversial, and even if the person gets the facts wrong, they're not likely to harm that person's esteem in the community. So my strong advice would be for you not to give job references when you get a call to confirm someone's employment. It is true in Texas and in most states there is a statute that we have that protects employers who give job references even if they are negative. But the statute has an exception. It doesn't protect employers who act in bad faith. And so there is a bit of wiggle room there for an employer to, or for a potential former employee to sue, saying, well, Bob defamed me. He gave a false statement that lowered my economic abilities to earn a living, and he acted in bad faith. And so, again, better just to probably not share that information at all. That's probably the more cautious route. Now, you may think to yourself, well, but what if I just want to give a good reference? Surely I can do that. What's the risk associated with giving a good reference? Well, there are two risks associated with that. So generally, employers don't even give good references. The first risk is that one person's good reference can be another person's bad reference. So let's say I get a call on Teresa. Somebody wants to get a review, or wants to get a reference on Teresa, and I might say all kinds of lovely things. But in passing, I say something like, yeah, I really admire how awesome Teresa is with our special needs customers. I guess she gets that because she's raising her own special needs child and doing a wonderful job doing it too. Again, that all sounds really, really positive. But let's say the employer hears that and thinks, oh, wait, Teresa has a special needs child? Special needs children are oftentimes sick, or they need special care arrangements. So Teresa's going to miss a lot of work, and I don't want to take that risk. So even though she sounds awesome and wonderful, I'm not going to hire her because she is a special needs kid. Well, maybe the person who gave the review has confused Teresa with Samantha. Teresa doesn't have a special needs kid. Teresa lost out on a job because of this confusion about who the people are. Or maybe Teresa never had a special needs kid, and Teresa just happened to have been really good with special needs customers, and that was the manager's drawing a conclusion that wasn't valid. Or maybe Teresa's special needs child is now an adult who lives independently, and there's not even any issue with respect to time off. So you can see how even something that sounds good, sounds positive, can actually be interpreted in a negative way by that potentially new employer. Another reason that good references can be dicey is that if it becomes known in the community that you will give good references, then when you refuse to give a reference for, Paul, the candidate, that employer who is calling you up will think, well, that person usually gives references when they're positive, so this company must have only negative things to say about Paul, so therefore I'm not going to hire him. So it's even possible, it's a little bit of a stretch legally, but it's even possible that a court, that a jury might conclude giving no reference at all when it's known in the community you do give positive references can itself be some kind of defamation. I mean, it's a stretch, but it could happen. So the bottom line is, probably best to give no references or just kind of name, rank, and serial number type of references when you are giving reviews of former employees, or when you are given that opportunity. On the other hand, when you want to get references, there's very little downside to you contacting former employers with the permission of the candidate, and also personal references to find out what you need to know. Again, that can reduce the chances of that negligent hire claim, and that can also help you find better candidates. Some of the data you get through those reference calls may be data that you shouldn't use, but having it available, asking those questions, again, you're going to want to be very careful about how you phrase those questions, but asking those questions can give you information that's going to help you make better choices. So ask the questions when you are hiring, but don't answer the questions when you get the call from about a former employee. So we'll go through in our second lecture, we'll talk about our second item, which is the discrimination in the selection process. At this point, just a little bit of a context here, we have covered this first item here, utilize job descriptions, qualifications, and other tools for legally selecting employees. If you have any questions about this first topic or any of the other topics we'll be covering in this chapter, please email me with questions or stop by my office hours so we can discuss it in more detail. I thank you for your attention. I look forward to having you here for our next part of this lecture. Thanks.